Hello NABU students. Now we're starting topic 2 in the lecture guide, and so we're starting at slide 22, the Canadian legal system. Slide 23 starts off with obviously the most appropriate spot, and that's the Canadian Constitution. Now the Canadian Constitution is a little different than most other countries. Our constitutional documents are numerous. The United States has a Constitution Act, and while that's it, Mexico has a Constitution Act, and while that's it, we, however, have two cornerstone constitutional documents, one when Canada was formed in 1867, and one when we repatriated our Constitution Act, or our Constitution in 1982. What's repatriation mean? Well, our constitutional protections for civil liberties, for example, came from tradition. Traditionally, with the Magna Carta and onwards, the United Kingdom developed protections of their civil liberties, but it was always through the courts, and so it was by tradition as opposed to actually being itemized in a document. So we, in 1982, were following the United Kingdom, and our protections were by tradition. Pierre Trudeau, who was responsible for the repatriation of our Constitution, wanted those protections outlined. So let's take a look, first of all, at the cornerstone document, the Constitution Act of 1867, when Canada was formed. Its actual name at that time in 1867 was the British North America Act. It's an act of Parliament, and what it did was it created the Confederation of Canada. The United Kingdom is a small country, and so a unitary government worked for it, but in Canada, because of the vast size of the country, they decided that they should have a confederation, which meant dividing the powers between the federal government and the provinces. So the British North America Act of 1867 is a UK statute. That document is actually still in the United Kingdom, and it's on display in one of their buildings. And when I was there doing my pilgrimage and to see the Magna Carta, I wanted to get into that building and actually take a look at the British North America Act. Unfortunately, the lineup was horrendous, and so we decided to give it a pass. We didn't have enough time. Canada has asked on numerous occasions for that document to be sent to Canada so that we would have it here, but the United Kingdom rightfully says no, it was an act of Parliament of the United Kingdom, so it should stay there. That aside, let's look at the two key sections of that document. In section 91, the powers of the federal government were outlined. There was the criminal law, for example, because they wanted the criminal law being consistent across the country. Transportation, because that's a cross-border issue. And then communications, again, because the communications was cross-border. They all fell under the federal government. There's numerous items outlined for the federal government, but those are the three key ones specific to a topic. And then there were two powers left to the federal government, which were a little different. One was the emergency powers, or what we call the POG powers, the Peace, Order, and Good Government Clause, which said that in the event of an emergency like a war or a COVID-19 pandemic, there had to be a unified response. So consequently, the emergency powers was given to the federal government. The other one was in 1867, the founders, the fathers of Confederation, were smart enough, I think, to realize that they could not see into the future. I have heard so much. I've been following the COVID crisis and the crisis of the Trump presidency in the United States long enough to realize that the Americans are under the impression that their founding fathers were these amazing people, George Washington, Thomas Jefferson, and they take the position that, gosh, they just knew what to put in to the Constitution, and they knew how to draft it. And all you have to do is look at the the right to bear arms, and they were really not all that clear. But anyway, they think that way. Well, our founding fathers said, okay, we cannot see into the future. We cannot see for example, we cannot see the development of the internet. We cannot see the development of cell phones. And so, and personal computers, we can't see that. We know it's going to happen, but we can't see it. No, they just realized there were things that were going to develop that they just had no idea about. So they gave the residual powers to the federal government. Anything not already covered, which might come up in the future, falls within the powers of the federal government. Section 92 outlines the provincial powers. And the provinces have the right for civil and property rights. Oh, civil rights. Oh, that must mean protection against discrimination. No, it has nothing to do with that. Remember when we were talking about the public law and private law? So I talked about the criminal courts, and then I talked about the civil courts or the private law courts. That's what civil means. Okay, in that context. So civil and property rights. Property means the ownership of property, including things like guns. Okay. Now, education was given to the provinces, and that shows a lack of forethought, I think. Education was important, but it wasn't paramount like it is today. And so they thought the provinces could have their own education, particularly because Quebec wanted French language education, they wanted French history education, more so than the English provinces, and so consequently they gave the provinces the right to education. So we do not have any consistency across the country. The provincial governments were given the right to certain provincial taxation and things like that. So there's more items than just listed on slide 23. But one of the key ones was they gave the provincial governments the right to establish municipal governments and to do the laws for them. What this meant was we had no consistency because the provincial government said, oh well, passing bylaws for not spitting on the sidewalk and snow removal and things like that, that's small potatoes. And so let's just delegate it to the municipalities. So they delegated it to the cities, towns, villages, boroughs, and shires. Well, we have no shires. We have no hobbits. That's a joke from the book about the hobbits and. But England had shires. The Shire of Nottingham was the sheriff of the Shire of Nottingham, and we don't have boroughs per se. Although there were some in Ontario in the early years, there was Peterborough and Scarborough, but they've developed into cities. So these municipalities had the right to make their own laws, and again, there's a lack of consistency, but it's not terribly critical. All right, so that was our one cornerstone document. The other cornerstone document is the Constitution Act of 1982. The really important element of this is it incorporates our Charter of Rights and Freedoms. Now, I always have a sort of a trap in my exam questions. Sometimes I say, what is the statute that protects our civil liberties? The knee-jerk reaction is the Charter of Rights and Freedoms. But the Charter of Rights and Freedoms is not actually a statute. Okay, the statute is the Constitution Act of 1982, and the Charter of Rights and Freedoms is attached as an annex to that. Okay, it outlines our fundamental freedoms, and the legal rights are protected supposedly in Section 1. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Okay, so there's those two documents. Now, why do I say it's in numerous documents? in actual fact, our constitutional document started in 1763. General Brock defeated General Montcalm. General Brock was the general for the English. Montcalm was the French general. They met on the Plains of Abraham. They battled it out, and the British won. And France ceded the colony of Quebec to Canada. They did this in the Proclamation of 1763. Well, that's got to be one of our constitutional documents, all right? And then very shortly thereafter, the United States starts getting muscly and belligerent, and they have this manifest destiny where they're going to take over the whole of North America, and so they're sort of eyeing the Canadian provinces to the north. Britain had a huge empire, was fighting wars everywhere, and thought to themselves, well, we don't have enough strength to actually prevent the United States from taking over Canada, particularly if Quebec, French Canadians really didn't like the British, particularly if the Quebec colonists did not side with the British. And so what they did in 1774 was they passed the Quebec Act, which allowed French Canada to keep its language, its religion, and its laws. Okay, so the laws, well, what was the laws? Well, the law was civil law, because that was a French colony, and the civil code was applicable there. Well, they were allowed to keep their civil law. And then eventually, in 1867, 4 provinces joined together to form Canada. There was Quebec, Ontario, New Brunswick, and Nova Scotia. And then after that, other provinces joined. Well, Manitoba joined first in 1870 as a very small province. They called it the postage stamp province because it was like a square. And then eventually they incorporated more territory, and it became a rectangle, and then it now is the shape it is today. So consequently, in 1870, that joining Canada is part of a constitutional document, and then as it expanded, there's 2 more documents that become part of our Constitution. British Columbia joined in 1871. The deal was if Canada, the 4 provinces, built a railway, I guess there's 5 provinces at that point, built a railway from central Canada to British Columbia, we would join. The Canadian Pacific Railway was completed. 1871, BC becomes a province. Alberta and Saskatchewan joined in 1905 to become provinces. Those are constitutional documents. Then in 1949, for example, Newfoundland and Labrador joined. 1931, I think it was, the Statute of Westminster allows Canadians to have their own ambassadors internationally. In 1949, we had a statute that said the Supreme Court of Canada is the highest court in the land. Up until then, you could actually appeal to the Supreme Court of Canada and then make an ultimate appeal to the Privy Council in England. And it's an ongoing process. Canada is made up of 10 provinces and 3 territories, but originally it was only 2 territories, the Yukon and Northwest Territories. Northwest Territories was vast, and there was obviously differences in the makeup of the population. So in 1999, we have another constitutional document which creates the territory of Nunavut. So all those together make up our constitutional document, and quite often in my midterm exams, I put a question on about our Constitution, the division of powers, and why our Constitution is said to be made up of many documents as opposed to just one. The next slide, which is slide 25, we get into some of the mechanics of the Canadian legal system. And there's sources of law in Canada, obviously, and I wanted to describe those a little bit. First of all, there is judge-made law. We've talked about precedent in the common law jurisdictions. Judges make decisions, and those judgments become precedent in subsequent cases, and so there's this body of judge-made law out there. Now, you'd think that nowadays with the legislatures and the House of Commons passing legislation, there would be no more judge-made law. In fact, there is in two respects. First of all, there are things not covered by statute. For example, if one of you was an irritating student and I got upset in class and I went and I gave that student a sock to the jaw, I could be charged with a criminal offense. That's fine. The government convicts me and I have to pay them a fine. Does not help that student recover damages to repair his jaw and his teeth because I am so strong that I caused all sorts of damages. What that student would have to do is they would have to sue me for battery, which is a common law tort. Battery is the merest unconsented to intentional touching of another, as we'll see later on in the course. So he sues me to get damages and an injunction to stop me from doing it in the future. Well, there's no Battery Act. You know, there's a Sale of Goods Act, there's a Competition Act, there's a River Rafting Act, there's a Beekeepers Act. We have so many statutes, but there is not a Tort Act or a Battery Act. So what that student would have to do, or that student's solicitor, barrister, would actually have to go and look at case law and find some cases where somebody socked somebody in a jaw, and that's the tort, and so that case would be used as precedent. And then you could get a number of cases which gave a range of compensation so that you could establish the damages. All right, so that judge-made law. The other way that judge-made law is created is interpreting statutes. The legislature or the House of Commons pass a statute, and there's a sort of a saying at law that that statute or a provision in it is not finally settled until it has been judicially interpreted. So there's still judge-made law occurring. Now I'm talking about statutes. There's statutes like the Criminal Code, the Human Rights Code, the Labor Relations Code, Sale of Goods Act, the Competition Act, the Business Practices and Consumer Protection Act. There's all sorts of statutes out there. Now, what's a code and what's an act? It depends upon the nature of the statute itself. I think one reason why the Criminal Code is called the Criminal Code rather than the Criminal Act is that inside that document, of course, there is a criminal act that a perpetrator does in order to commit a crime. So it would be unclear if you talked about the criminal act, meaning the whole statute of all the sections, and the criminal act of a perpetrator. So they call it a criminal code. That's the only reason I can think of, because there's really no discernible difference between a code and an act. They are both statutes. Okay, so in BC, for example, the BC government passes the Labor Relations Code. And this is the statute that governs negotiations and problems between the BC government and the Civil Service Union, or BC businesses and their labor unions. So it establishes how you get to a collective agreement. But then if there's a dispute over the wording of the collective agreement, the Labor Relations Code does not give you the procedural law necessary to actually settle that matter. And so the labor minister is said to be the responsible minister in the Labor Relations Code. And the labor minister is given the power to pass regulations for the application of the code. So you got statutes and regulations. Okay, they go together. Now, I'm going to jump down to the bottom of slide, was it 25, because there we see that difference between statutes and regulations a bit clearer. Substantive law is the rights and duties of each person in society. What's that mean? Well, the criminal code says that, you shouldn't rob somebody, you shouldn't shoot somebody, you shouldn't peddle drugs. That's the substantive law. Those are the things that you should not do. At common law, judge-made law, there's a rule that says you should not breach enforceable contracts. And so that's the substantive law. Oh, and also, popping that student on the chin, you should not commit a battery. So we have this situation where we have substantive law. But let's say you and I have a contract, and you breach that contract, and I want to sue you. How do I do that? You're sued. No, that's obviously not what we're talking about. The procedural law then provides a whole series of rules that allows me to avail myself of the provisions of our court system in order to sue you. I have to go down to the courthouse. I have to fill out a notice of civil claim if it's the Supreme Court, or the notice of claim if it's the Provincial Court, small claims. And I have to pay a fee, get it stamped by the registry. I have to serve it on the defendant. The defendant then has a certain period of time at which they can file a statement of defense if it's a Supreme Court matter, or a reply if it's a small claims court matter. And thereby, bingo, we have this procedure that will allow the court system to resolve the claim. Okay, so the legislatures pass statutes in order to for the better government of Canada. But what happens if there's a situation where let's take the provincial legislature, for example, want to pass a law that is not contentious at all, okay? And a good example of that is the Register of the Land Title Office in BC is responsible for keeping hard documents of all documents filed with them. So I buy a house, I file a Form A. I have to get a mortgage to buy the house, I file a Form B. I want to develop property, so I have to file a covenant covering the property. The government comes along and says, okay, yeah, you're developing this property, but we have a electric line going through there, and so we need a right-of-way. And along comes the municipality and says, okay, you've got all that property, but we have to go on there and provide sewers. So we have to have access to your property, and so we have to file either rights of way or what's the other name? It escapes me right now. Rights of way or easements. Okay, and so all these documents are filed at the Land Title Office, and the registrar has to keep copies. Well, the registrar now has buildings and buildings and buildings full of all these documents. And the registrar has to be able to provide people, lawyers who ask to do a search on the property, copies of these documents. The danger is they not only have to keep a whole set of the documents here, but they have to keep another whole set of the copies over here because this building might burn down. And so they've got buildings and buildings full of all these documents. The registrar says in the electronic age, that is silly. I could put all the documents in that one building on one CD. So, but he's not allowed to because the law says the registrar must keep a hard copy. So the registrar wants to change that law to allow him or her to keep electronic copies. Do we want our House of... No, it wouldn't be the House of Commons. Do we want our BC legislature to then introduce a bill in first reading, do second reading, have it go to a committee to be studied, go back for third reading, a vote, and then go to the lieutenant governor to be voted upon? No, because nobody cares except the registrar of the Land Title Office. So these kinds of routine legislation can be passed by orders in council. Council? What's the council? Well, in actual fact, we don't have a provincial cabinet. It's a council of provincial ministers. But that sounds like small potatoes. I don't want to be a councillor. I want to be a cabinet minister. Sounds better, right? So by tradition, we have cabinet ministers and a cabinet. By law, if you read the actual wording of the law, we have a council. So you have this document, and if I'm able to put Chapter 1 on Moodle, and I'm waiting to find out. In that chapter, there is actually a picture of an order in council, and it's on page 23. Basically, at the top, there's a place for the lieutenant governor to sign, but that's not until after it is completed. Okay, there's the law is written out by the attorney general. He signs it. The presiding member of the executive council signs it. Who's the presiding member of the executive council? Well, that's our premier. Okay, or if the premier isn't around, then it would be the deputy premier would sign it. So once that's done and the wording of the statute is attached to it, and this one is actually concerning the land title office, then it goes to the lieutenant governor, okay, because it's now passed by our legislature, but it's not yet law, and the lieutenant governor of the province of Canada signs it and then proclaims it law by depositing it in the records of the government. Now, who's the lieutenant governor? We've completely divorced ourselves from the United Kingdom with the repatriation of our Constitution in 1982. Almost completely divorced ourselves from the United Kingdom. Who's the head of state? The head of state is the Queen. Okay, so the Queen Elizabeth II is still head of state in Canada. But she's over there in England and she's doing her thing in England. She has nothing to do with running Canada. But the Queen's representative federally is the Governor General of Canada, and the Queen's representative in each of the provinces is the Lieutenant Governor. So the Queen's representative in the province of British Columbia would sign the order in council. That would make it law. Okay, and we're talking about the law of Canada. So 9 provinces and the 3 territories are common law. Quebec has civil law. Completely? No. The public law, the Criminal Code, Competition Act, all those statutes, are for all of Canada. Okay, including Quebec. Provincially, however, remember in Section 92, civil and property rights? Well, civilly in the province of British Columbia, we have common law. Civilly in the province of Quebec, they have civil law. Okay? And so the Civil Code in Quebec, which incidentally is not one book, it's a multitude of books because it's like basically the same as all BC statutes. The Civil Code applies to private law in Quebec. Then the next category, number 5 on my list, and there's no magic to that numbering system, that's just me, is administrative law. We have the Labor Relations Board in the province of British Columbia. Now I'm just going to glance ahead at my slides. On slide 28, when we look at an overview of Canada's court system, we see at the bottom of the federal line something called federal administrative tribunals, and then we see at the bottom of the provincial line something called provincial administrative tribunals. These are not courts per se because they're not run by judges. They are run by appointees from the provincial government, and they were brought into our system because our courts are being overrun with cases. The backlogs were terrible. So they thought, well, let's get these administrative tribunals, seeing how many of these cases just a government representative making a decision at a tribunal level can eliminate this flood of cases. If the decisions in those cases are not satisfactory to the parties, then they can be appealed. For example, at the provincial level, the provincial administrative tribunal gets appealed to the provincial Supreme Court, which in BC is the BC Provincial Supreme Court. You do not go to the provincial courts per se. Okay, provincial court is small claims. BC Supreme Court is the other court in BC. So you go to the BC Supreme Court and you get a decision, final and binding, no further appeals. So it cuts down the backlog in our court system. When the Labor Relations Board makes a decision on a dispute between a business and its union, it looks at precedent and it follows the precedent, and they issue a decision, and it looks like judge-made law. It sort of looks like, walks like, quacks like a duck. Is it a duck? Well, in fact, no. Okay, so it's not judge-made law, and the reason is that administrative tribunals are not bound by precedent. Precedent allows for predictability and consistency, though, and so the Labor Relations Board slavishly follows precedent. So much so, it used to be that you could appeal from the Labor Relations Board to the BC Supreme Court, and then from the BC Supreme Court to the Court of Appeal. And they've eliminated the appeals because the Labor Relations Board is just so good at what it does, all right? So you have this body of law being built up, but it's not judge-made law. It's called administrative law. So you have the Labor Relations Board, you have the Employment Standards Branch, and I've done Employment Standards Branch hearings, and I've brought in cases, and the hearing officers have always followed those cases. So again, they build up this body of law which looks like precedent and can be used by precedent, but it is not necessarily final. In my legal career, I'm really fortunate. I've done administrative tribunal cases, and I've done small claims court cases, and I have done Supreme Court cases, and I've even done one Court of Appeal in BC case. And I only lost once, okay. Now, I did lose some provincial small claims court cases, but in each case they were appealed to the BC Supreme Court, and the decision of the lower courts was overturned, and I did win. So I'm feeling, pretty good about that. The one case that I lost was a Workers' Compensation Board case because WCB, when someone dies, pays out money to the deceased's spouse. One of my clients' wife died, and WCB said, yes, we're going to take this whack of money and we're going to give it to you. Now, how they give it to you is critical, because if they give it to you over a number of years, then you can minimize the tax consequences. But if they give you a lump sum payment in that 1 year, it would be added to your income and put you in a really high tax bracket, and the government takes back something like 50 to 55% of it. So consequently, they always did it over a number of years. When my client made the claim, they said, oh, we're just going to give you a lump sum. And he came in and he said, whoa, he said, if they do that, they're going to take so much money back. And so we went to a hearing, and I brought in cases where they had done it over the, a number of years. And they just said, yeah, we know, but we've decided to change our mind. We think it'll be a lot easier for us if we just get a lump sum payment, and who cares about you, right? Then you have 60 days to do an appeal inside the administrative tribunal. And my client said, okay, should we appeal? And I said, it's up to you. But they're not bound by precedent, so they didn't make a mistake. Okay, so when you appeal, it's unlikely you'll be successful. So he elected not to go for an appeal, and because there had been a couple of other appeals on the same basis, and they'd all been dismissed. So he didn't want to spend the money on the appeal, and I don't blame him. So then 11 months later, the workers' compensation goes, oh, you know what? We think it would be better if we gave, yearly payments. And my client came back to me and he said, well, what about me? And I said, well, you fell between the cracks. They are not bound by precedent. They can flip-flop back and forth, and there's nothing you can do about it. They're not bound by precedents because they're not judges. Okay? So anyway, that's the administrative tribunal system. Back to slide 25. Administrative law, that body of law done by administrative tribunals. Oh, and incidentally, where do you get the name tribunal? It bothered me for years because tri sounded like three. So I expected a tribunal to have three government officials, maybe because they're not as good as judges, right? And so when I started going before the tribunals, there was always one officer. And it was one of those things that, nagged at the back of my mind for the longest time, which just goes to show the more you read, the more you're well read, the more you're going to know. I was reading a novel written by an author in BC, Jack White. He wrote about the Knights of the Round Table. He wrote about the Knights Templar, and I was reading all those books. And he wrote about the early governor of Rome in the United Kingdom. And in there were disputes, of course, that occurred within the Roman army. Okay, so it's trial by ordeal and trial by fire for the Brits. But inside the Roman army, if there was a dispute, the dispute would go to a tribunal. And it described the tribunal as an officer at a certain level inside the Roman army. Okay, so just an officer of BC is the tribunal. I don't think that'll be on the exam. Anyway, then there's the sixth source of law, and that's the municipal bylaws and regulations. All the little municipalities, the cities, and everything can make up their own rules. And as I said, there's no consistency. For example, in North Vancouver, the city of North Vancouver, if it snows, you have to clean the sidewalk in front of your house. Okay. And it snowed one year when I lived there, and I rushed out because I knew the law, and I cleaned my portion of the sidewalk, and I looked up and down the whole street. Nobody else cleared theirs because nobody knew the law. And it turned out it didn't matter anyway. But that's the city of North Vancouver. The division between North Vancouver and the city and the district is Lonsdale. And on the east side of Lonsdale, the law is different. You do not have to clean its sidewalk. So again, there's these laws. Then I added the seventh one, military law. Not that we have anything to do with it. It's just to be more complete. We have a military code of conduct. We have military police, military prisons, military lawyers, military judges. A whole system of courts and laws for the military. So I just put it in there to be complete. Now the eighth one we have to be a little careful about. And I mean that because international law is very distinct from the other law. Okay, and so I put it in there because I thought, particularly looking at North American law, we should realize that besides the law of BC and the law of Canada, there's this international law which transcends boundaries. Now, it can be judge-made law. For example, we will go through a case called Sharn Importing versus Babchuck. It involves a Quebec business, a BC business, and the BC business has an office in Alberta. So it's cross borders, and it is international, and yet it's inside Canada. But then there's also cases where a BC business is suing a business in the United States or vice versa. So there's judge-made law that goes across boundaries, and that falls under international law. And then there's public law on top of that. There is the U.S. Mexico-Canada Agreement, which is the precursor of the precursor? No, that's before the result of the amendment to the North American Free Trade Act. Because it's cross-border and it's public, it falls under statutes and regulations, and yet it's very much different than the BC's Sale of Goods Act, for example. And then there's the conventions passed by the United Nations, which apply to all three countries, and even though it might require enabling legislation by either the federal government or the provinces, it is somewhat distinct. So I just separated them out. Now, I've been talking about public law and private law, and further clarification of that is public law is the conduct of government on one side and a government on the other. So this would be a constitutional challenge. The federal government tries to pass gun control legislation, and the province would say, no, that's civil and property rights because guns are property. We should regulate it. You cannot do it. And so they'd do a constitutional challenge, public law. The case of Regina versus Dudley and Stephens. Regina means the Queen versus Dudley and Stephens, two individuals, the government on one side, private people on the other, public law. Canada Revenue Agency versus Graham, the government on one side and a person on the other. Private law, or public law rather. Private law is Holden versus Graham. Graham breaches my contract, I sue him. The government doesn't care. Okay, the government gives us a court system to resolve our problem, but they don't care whether I'm right or he's right. Okay, so that's private law. Or groups of persons, you can have an unregistered society, which is just a group of people, versus a supplier, something like that, okay? Or you might have three plaintiffs who were, injured in a car crash, and they're suing the negligent driver because they think they should be compensated more than the insurance. Well, that would be three separate lawsuits, but the judges won't go for that. They'll consolidate the cases because the three people were injured by the same accident. Okay, so people on one side and a group on one side and a private person on the other. All right. See the public and private diagram in the lecture materials. That's the books that you buy at the bookstore. I show a little diagram of a scale, and on one side it lists the things that fall under the public law and the list of the things that fall under private law. We've already talked about the international, falling under both. The other thing that falls under both is administrative law, because the Labor Relations Code, for example, resolves public law disputes between the government and the civil service, but it also resolves disputes between private businesses and unions. But at the top of the list, there's the constitutional matters. That's obviously public. Now, the Constitution Act is not a source of law because it is just a statute, Constitution Act. So it's covered by acts and regulations in the previous diagram, or in slide 25. But then there's the criminal code, obviously, and then there's marketing and advertising law, and that sounds like it should be on the other side. That sounds like business. But when someone falsely or misleadingly advertises a product, you make a complaint to the Competition Bureau, which is one of those administrative tribunals that I talked about, and then they go after the person that has falsely advertised their products. So it's on the public law side. On the private law side, you've got contracts. Now, it's not a perfect division again because you might have a contract with the government, so they don't pay you, you sue them. It's a private law matter, but it just happens to involve the government. So there's contracts, there's torts, there's wills and estates, there's property law, the ownership of property, that sort of thing on that side. Okay, enough said about that. Now we're going to get into the court system, and this is, let me just see where we are here time-wise, because, yeah, okay, we can just do the court system, and then I'll take a short break and come back. Yeah, all right. So this is an overview of the court system in BC, and there's a trap here, and that is that on the exam, quite often, I give that diagram, but I eliminate the court-martial and military courts, okay, because that's just not applicable to commercial law. So we're looking at the federal sphere and the provincial sphere. This is an overview of Canada's courts. So under the provincial area, you'll see provincial and territory superior courts. we do not have a superior court in BC, okay, or a court called the Superior Court. Okay, we do have a Superior Court, but it's called the Supreme Court of BC. They use a generic term because the provinces can use any name they want. BC, it's the BC Supreme Court. Nova Scotia, it's the Nova Scotia Supreme Court. Alberta, it's the Alberta Queen's Bench. Saskatchewan, it's the Saskatchewan Queen's Bench. I'm not sure whether Manitoba's changed. In Ontario, there's the High Court, okay? And in Quebec, there is something called a Superior Court. So the trap is, if I put that diagram on the exam, and I hope you're listening, I could say, this is a 5-mark question, identify 5 courts of first instance and explain them. All right, so you would say, oh, well, there's the Provincial Small Claims Court, and then there's the Superior Court of BC. Yeah, no, it's the Supreme Court of BC, okay? And then you're going to lose some marks. So just watch out for that. We have the Provincial Court, which has 5 divisions, which you don't have to know, but it's small claims, criminal court, family court, juvenile court, and the traffic court. Okay, so but it's just called Provincial Court of BC, and then you can appeal from the Provincial Court of BC to the Superior Court of BC, no, to the Supreme Court of BC. And then if you have appeal, you can appeal to the BC Court of Appeal. And then you can apply to appeal to the Supreme Court of Canada, maybe. Okay, so that's the system. Now below the courts is the administrative tribunals, but we've already dealt for that. Okay, so that's the provincial side. Now, small claims provincial court has a monetary limit, and it used to be $5,000, and then they were thinking, well, let's increase it to $10,000, but no, they increased it to $25,000 instead, and I think they've increased it to $35,000, but I am going to, in a moment when I take my break, check to see if they've actually upped that. They were talking about making the small claims court limit $50,000. So if I want to sue you for breach of contract, it has to be under $50,000. If it's $55,000, I can make up my mind to go in small claims, which would be less expensive and faster, if I forego the 5. Okay, so instead of suing for $55,000 that you owe me, I would sue for $50,000 so I could go in small claims. But you can start in the BC Supreme Court if you're owed $10. The only reason you wouldn't would be it was so expensive, but if there was another issue related to that, for example, a defamation, which small claims cannot do, or a property law matter, which small claims cannot do, then you would sue in BC Supreme Court. Okay, any court, you can start there. It's just that it might be more financially beneficial to start in small claims. Okay, so that's the provincial court side. Now, we have the federal court side, and there's two courts where you can start. One is the federal court. If you had a marine law issue, falls under the government. If you have a Bank Act issue, falls under the federal government, so you'd start there. If you have an intellectual property claim, you would start there. Preferably, you could start that one in the BC Supreme Court. The problem with that is someone's infringing your trademark. You sue them for trademark infringement, and you win in BC, yay! But then you have to register it in Alberta, and then you have to register it in Saskatchewan, you have to register it in Manitoba, and on and on and on. Whereas if, in order to stop someone in Canada from infringing your trademark, if you go to the federal court, you get a judgment which is good all across Canada. Okay, so there's strategy behind that. Now, the other court that you can start in is the tax court. That is... handles only matters with respect to the Tax Act. And the interesting thing about that is if you lose, you have the right to appeal to the Federal Court of Appeal. That's the court of last instance, okay? You lose in federal court, you cannot appeal to the Supreme Court of Canada. The judges in the Supreme Court of Canada have made it plain that they will not hear any tax cases. they're far too busy and far too important, I guess, to be, have their docket cluttered with those matters. So Federal Court of Appeal is the final court from the Tax Act. Okay, now I actually mentioned that it might be on the exam and you'd have to tell me 5 courts of first instance. This is a term which is not in the lecture guide, but is one that you should know for examination purposes. What's a court of first instance? Well, pretty obviously, if you look at the words, it means where you have to start. Okay. Now, when you look at this diagram and you eliminate the military courts, the tribunals aren't courts, so that doesn't count. Well, Provincial Court in BC is a court of first instance. You can start in the BC Supreme Court. Okay, good so far. BC Court of Appeal? No, Court of Appeal. By the very name, you cannot start there. Federal Court. Okay, well, the Federal Court, you start there with a trademark or a marine law issue or a bank act issue. And then Tax Court, oh, well, it's a court, so those are 4. And then you look at the diagram and you go, what's the other one? Well, the only other one that it can be is the Supreme Court of Canada. Now, Supreme Court of Canada handles appeals from you and I, okay, but if there is a constitutional challenge between BC and the federal government, for example, you do not start in the BC Supreme Court, okay? You can make a reference directly to the Supreme Court. So it would be reference re Gun Control Act, because the federal government wants to file an act or pass an act called the Gun Control. And BC says, no, wait a minute, that falls under our powers, civil and property rights. And the federal government saying, no, we're doing it to combat crime. There will be a constitutional challenge there. If BC had to start in the BC Supreme Court, and it took 3 to 5 years to get in there, and then it had to appeal to the BC Court of Appeal, and it took 2 more years, and then it had to appeal, and it took 3 more years to get into the Supreme Court of Canada, that'd be 10 years. Well, the federal government would have passed the gun control legislation and started implementing it, which means licensing owners of guns, collecting money, starting a gun control registry, searching and seizing without warrant because they suspect somebody has guns. And they do that, and there's all sorts of court cases, and there's also fines, and there's all sorts of taxes collected by the federal government. And then the BC finally gets all the way to the Supreme Court of Canada, and the Supreme Court of Canada says that legislation is ultra vires the powers of the federal government, which means beyond the powers of. So they strike it down. What do they do with the people they put in jail? What do they do with the tax money that they've collected and spent? What do they do with the gun registry, which has all sorts of personal information in it? It would be absolute chaos. So when there's a constitutional challenge, the provinces and the federal government cannot wait and work their way through the system. So they're allowed to make a reference right to the Supreme Court of Canada for a declaratory judgment. Okay, there's another term you should know. A declaratory judgment. It means the act hasn't been passed yet, so they're not interpreting it, whether, what it means. They're deciding whether it should be passed or not. Okay, so declaratory judgment. Okay, so the 5 courts of first instance: BC Supreme Court, BC Provincial Court, Federal Court, Tax Court, and the Supreme Court of Canada. Okay, all right. Now I'm just going to take a short break here so that I can get another cup of coffee, and then we'll be back. Okay, I'm back after my break. I had a cup of coffee, I had a grilled cheese sandwich, and now I am getting into slide 29, dealing with a criminal law case versus a civil law case. But before I do that, I said I would check on the small claims court limit, and it is still at $35,000 in BC. Now, criminal law versus civil or private law case, see the lecture materials. In there, I put in a diagram, I believe, showing the difference. But I've also got it in my text, and if I can get that onto the Moodle, then we'll have, it'll even be better. However, what this does is it demonstrates the criminal court process, which is public law matter where someone's charged with an offense, and a civil court process, which deals with the situation where I'm suing someone over a breach of contract, which is more applicable to our course. Anyway, on the criminal law side, right at the top, it says a crime has been committed. It's assault, battery, armed robbery, murder, drug offenses, that sort of thing. And the charge goes to the Crown Counsel, Crown Prosecutor, who has a great deal of leeway whether or not it goes ahead. The matter can be stayed, which means it's put on hold. For example, they may have insufficient evidence to actually get a conviction at trial. The police are still looking into the matter, so they stay it for a while. Or they can go ahead. So it will be the Crown versus the accused. Okay, so it's the Crown, meaning the public law, government on one side, the accused being an individual on the other. The trial it goes to court. What's the level of proof? Well, it has to be beyond a reasonable doubt, which is a very high level of proof. Not absolute, but beyond a reasonable doubt means if there's any doubt, then it has to be found in favor of the accused to prevent sending as many innocent people as possible to jail. I mean, we do, unfortunately, send some innocent people to jail, but it's because the system is run by humans and we make mistakes. So beyond the reasonable doubt, the accused has the choice of trial by judge alone or trial by judge and jury. And what this means is let's look at it this way. Regina versus Dudley and Stephens was a case where 3 men and a boy were lost in a life raft in the South Atlantic. Two of the men kill the boy, and the 3 of them eat the boy's body to try to survive. This is in 1884. They're finally rescued, and they're put on trial for murder. Well, you would never have a judge and a jury because, I mean, the jury would have, women that are mothers and men that are fathers on there, and they killed this young boy. And so, your guilty decision would be almost absolute. Their defense was that it was absolutely necessary for them to do that to save their lives and the lives of their families back in England, who would have been in poorhouse and slave workshops and things like that, had they perished. So they said it was necessary. Well, the defense of necessity is a very technical term. And a jury would go, oh, yeah, you killed a boy, who cares about that? Well, a judge alone can say it's terrible that they killed a boy, but let's look at this legal argument, okay? Whereas there's other times when you want to have a jury trial. On the civil law side, for example, if somebody injures you in a car accident, a civil trial with a jury, the jury's more likely to be very sympathetic to the injured plaintiff, okay? So anyway, the accused gets to choose judge or a judge and jury, and it's 12 of your peers. So if you're a drug dealer, does that mean you get 12 drug dealers on the jury? No. Innocent until proven guilty in common law. So they assume you are an upstanding member of the community until such time as you are convicted. Therefore, they're looking for 12 upstanding people in the community. How do they find them? They just go to the voters list and they look down and they take a big batch of people and they send them jury summonses, and then they have to turn up to see if they get elected to the jury. Now, if it goes to trial, at the end of the trial, there's a verdict, okay? and the verdict is either guilty or innocent. Okay, and if it's innocent, then the accused goes free. If they're guilty, then there's another almost little trial after that called the sentencing hearing, when the accused gets, or the convicted person gets to bring in evidence about, this is a first-time offense, I've never been in trouble with the law, I belong to the church, I go to church regularly, I'm on the bake sale committee, I volunteer with charity in my community, all the good things that the person has done. And then the Crown Prosecutor gets to point out, well, this is their only time they were convicted. They were charged with 5 other counts that, were not proved, and things like that, okay? And then they decide whether or not, or the judge then decides how long the person goes to jail for. The civil court process starts off with a breach of a contract or a tortious liability or an estate matter, and the matter then goes to the court, but not through the Crown. The plaintiff has to start an action in the Supreme Court of BC, or the claimant has to start an action in the small claims court in BC. And then if it's a plaintiff versus the defendant, or the claimant versus the defendant, as opposed to the Crown versus the accused. Now you have to be careful, because we see a lot of American TV, and it's the prosecution versus the defendant. They call the accused the defendant down there. That's U.S. law. Up here we call them the accused. There's thousands and thousands and thousands of civil claims filed in both small claims and the Supreme Court Registry. A much reduced, I was going to say very few, but no, a much reduced number actually go to trial, because between the time that the lawsuit is commenced and the trial date, there are settlements. Insurance companies used to have a terrible reputation, because you would make an insurance claim and they'd deny it. And then you would wind up suing them, and it would take something like 1 to 3 years to get into court. And so they would battle and battle and battle until the courthouse steps. You're going up the day of the trial, and the insurance company would say, okay, we'll settle. They would do that obviously, because if it's a $1 million claim, who gets the interest on the money, the $1 million, for the 3 years waiting for trial? They do. Okay, so the longer they can hold on to the money, the better off they are. So they tend to deny liability on their claims, and then they would have a settlement on the courthouse steps. Okay, trial in a civil court. What level of proof? Well, it's on a balance of probabilities. The scales of justice are absolutely level. The plaintiff must prove his or her case, or in small claims, the claimant must prove his or her case, and all you have to do is get one side of that scale of justice to tilt in their favor. Okay? Remember the experiments you used to do in high school, where you had a vacuum chamber and a scale inside, and it was perfectly balanced, and you would put a feather on one side, and that feather was sufficient to make that scale tip. Same thing in civil court. 50.00001%, the plaintiff is correct, the plaintiff wins. Okay, now I'm being a little facetious with the numbers, but either the judge or the judge and jury have to feel that the plaintiff has made out his or her case. So if it goes to trial, it's either by judge or judge and jury. And if it's judge and jury, then it's 8 of your peers rather than 12, because a civil matter is not as serious as a criminal matter, based on the fact that the criminal matter has punishment related to it, whereas civil matter is just supposed to be compensation. You have a decision by the judge. In a criminal matter, it's called a verdict. In a civil law matter, it's just called a judgment. Now, these are terms as they are usually and most often used, although judges in criminal matter can say, my judgment is in favor of the accused. Okay, so they're not bound to use specific terminology, but generally it's considered a verdict is criminal law matter, judgment is a civil law matter, as opposed to, example, the third situation where it is by an arbitration, and in that case, the arbiter's decision is called an award. So you get a verdict, a judgment, and an award. Good exam question there somewhere. If the judgment is in favor of the plaintiff or the claimant, then there will be an award of damages as a remedy, perhaps an injunction, and maybe an equitable remedy. If the decision is in favor of the defendant, then the matter is dismissed, and that's the end of it. Okay, so if we do get the chapter posted, it's on page 33, and I'll be working on that. All right, so that completes the Canadian legal system. I want to jump now and talk about arbitration, and then when we're finished arbitration, we'll talk about the American system, and very briefly, I think we'll talk about the Mexican legal system, although I have to be a little cautious because I haven't been involved in those, so I don't know as much about it. Okay, so let's see, where are we? That's just trying to decide whether we should go ahead with the arbitration, and I think we should, so let me back up here. All right, slide number 31. Slide number 31. The court cases are fraught with stress, they're costly, and they're disruptive. And the outcome is uncertain. I've never ever told a client, yes, we'll go to court and we'll win, okay? Because there are so many things that can happen that are unusual. For example, you get a judge less familiar with the nature of the action. You might get an inappropriate decision, that sort of thing. We'll go into that a little bit later on. But it's very costly. It's time-consuming. It takes anywhere up to 3 years to get into Supreme Court on a matter, sometimes longer, sometimes you get in quicker, but generally about 3 years. Well, a lot can happen in 3 years. The plaintiff could pass away, the defendant could go bankrupt, witnesses can move away and disappear or die. So many things. The subject matter of the court case might be destroyed. So it's justice delayed is justice denied, basically. Is there a better way? Yes, there is. It's called arbitration, or alternate dispute resolution, and it involves mediation and arbitration, and if it goes to arbitration, then you get what is called an award. Now, why go to arbitration? Because there are so many advantages over going to court, and we're going to go through them in a fair amount of detail. There are a number of disadvantages, but we're also going to go through those because it would be unethical to look at the advantages and not the disadvantages. But when I go through the disadvantages, I'm going to show you that most of them are I don't think they're disadvantages, or if they are, they're not significant. Okay, so looking at slide 32, the very first item on the list is you get to arbitrations faster. We have in Vancouver 2 arbitration centers. I'm familiar most with the BC International Commercial Arbitration Center. It's been around for years and years and years and years. And the president, used to come out and be a guest speaker for us, and he said you generally get into arbitration in about 4 months, 3 if you're lucky, a little longer if it's more complex. But 4 months as compared to 2 or 3 years, obviously it's much faster. Now, it's less costly to go to arbitration. It is not inexpensive. Okay, there's nothing about our legal system that is inexpensive. But years ago, I had a client who had a matter that was worth $35,000, and at that time the small claims limit was $20,000, and so he wanted to go to the BC Supreme Court so that he could claim the whole $35,000. I had stopped doing litigation at that point because I was doing a lot of teaching, so we were calling around to a number of law firms, getting sort of outlining the case briefly and asking for some sort of rough estimate of the legal fees. None of those law firms wanted to touch it. They said because their legal fees are going to be $35,000 to $40,000, and you may get party and party costs, which means if you win, the defendant has to pay some of the money from the legal fees to the plaintiff. They said, but that would be insignificant compared to the cost, and so you'd win in the BC Supreme Court, and you would ultimately not receive anything or very little at all. You could forego the amount over the small claims court limit and go in small claims, but if you're suing for $35,000 and you have to give up $15,000 so you can fit within the $20,000 small claims court limit, that's not justice. So obviously, if you have an arbitration, I don't even know the figures exactly, but something along the lines of $7,000 to $8,000 or $10,000 in legal fees and expenses, as compared to $35,000 or up. All right, so it's less costly. Not inexpensive, but less costly. Arbitrations can be easily confidential. This is a definite advantage because if I sue someone in the BC Supreme Court because I'm having a contractual dispute with them, and my contractual arrangement with them contains proprietary information that gives me an advantage over my competitors, well, while we were working together, everything was fine, but after a dispute arose, I want to sue this person, I want to get rid of him, I want to keep everything confidential. So we get into Supreme Court, and I say, well, I'm suing him, and I want to get rid of him because he's not doing my pricing system correctly. The judge says, well, what's your pricing system? And you go, oh, can't tell you, it's proprietary information, it's secret. Then the judge will say, well, you lose, because I can't tell if he's not doing it right if you won't tell me what it is. So, okay, it's a court case, so, like, what could go wrong? So you tell the judge, and the judge finds in your favor, or not, whatever. But then your competitor, okay, looks and says, oh, look, Peter Holden's company, he got sued. I wonder what that court case was about. Well, there's no way they can find out, right? Well, yes, there is. They go down to the courthouse registry and they go, hi, here's $5. Could I please see Holden versus such and such? And they bring the file and they give it to him. Because no Supreme Court case, no small claims court case is supposed to be confidential unless it is a matter concerning the sexual assaults against minors, pedophile cases. Those are confidential. The rest are not. There's supposed to be transparency in our justice system, and so all those are open. So they get, they bring the file, and your competitor looks in. He goes, "Oh, there's his secret pricing system. That's how he competes against us. Here's another $2. Could I get photocopies of these pages, please?" And you get the proprietary information. Go to arbitration, you just say to the arbitrator, I would like this confidential, please. And bingo, it's confidential. Nobody gets to see the decision of the arbiter. Choice of arbiter, the choice of the arbiter means that you have a definite advantage. I'll give you a really good example. I had a client in Gibson's a lady who wanted the old windows taken out of her house, about 5 of them, and new wood windows put in. And she found a person whose work was impeccable. He was an artisan, okay? And so what he would do is he remove the old windows and he would build these new windows and insert them with the glass, and it was really, really nice. Well, what happened was he said, okay, yes, I can do it, and here is my contract, which I want you to sign, and it gives you a fixed price. So this is the amount that this job is going to cost you. And so the woman thought, okay, well, that's fair. And she signed it, and he began working, and he rips out some of the windows, and he starts building the windows. And then he comes to her and he says, oh, sorry, I actually think that you should pay me more. You should pay me, and it was almost twice what he had agreed to. And she said, oh, no, you can't do that. We have a contractual agreement whereby the fixed price of this. And he says, yeah, I know, but I want you to pay me double, or I cannot finish the job. And she disagreed, and so he gathered up the windows that he had made, and he left the site, and she's got, windows partially taken out of her house. So she made a demand, and he said, I'll come back and I'll finish the job, but you've got to pay me twice the amount. And she said, but we have a contract. And he says, so what, right? So she decided she was going to sue him. They get into small claims court, and because it was a contracting matter, and because this woman just didn't like going to court, she asked me if I would do it. Long-time clients, so I gave her a really good price. And we go to small claims court. Now, we get to the registry, and I look at the docket, the list of items on the list for that day, and the name of the judge. And there's 2 matters on the list. There's a family law matter before us, and then there's our small claims court action. And then I looked at the name of the judge, and I thought, I don't recognize that judge. So I went up to the registry and I said, I'm sorry, but, Seashell does it. 1 judge, right? Huge court. 1 judge. So I went up and I said, who's that judge? And the registrar said, oh, well, as you know, the judge that was there had passed away from cancer, and we have this new judge, but he hasn't started yet. And so we're bringing up judges from Vancouver, and today we're bringing up a family law judge because the first item on the agenda is a family law dispute involving custody of small children. Very serious, right? And I said, oh. And my client said, what? What's wrong? And I said, well, we're getting a family law judge, and I wonder if he or she has done very much in the way of commercial law. Because remember, small claims does criminal matters, commercial matters, family law, young offenders, and traffic court. So we got into the court, and the custody matter goes first, and I was amazed at how fantastic that judge was. She just cut through all the emotional garble and the and the stress and everything, and got down to what was best for the child, made her decision, and bingo. And I thought, wow, is she ever good? And then we started our trial, and I'm not certain why, but she was incredibly animostic. She had a great deal of animosity and showed it towards my client, I guess because there was this woman who has this house that, she can put in wood windows are really expensive, and she's got a lawyer with them. And here's this poor workman on the other side. We get into the trial, and the workman's on the stand, and he's explaining why he should be paid more. And so I said, here's your contract, right? Yes. This contract you drafted. Yes. And it's signed by you, and it's signed by the claimant. Yes, that's correct. And up here it says fixed price, labor and materials. Yes, it does. Okay, why do you then think you should be able to have twice that amount? And he said, well, because I realized when I got in the job that it was going to be more expensive. But I said, but it's a fixed price contract. And the judge at that point says, oh, Mr. Holden, I think what he meant was cost plus. Well, it's his contract. He drafted it. He signed it. He said fixed price. How could he possibly have meant cost plus? Well, he's no dummy, right? And he turns to the judge and he goes, oh, yeah, that's exactly what I meant, cost plus. And I was astounded, and then we're going through the trial, and we get towards the end, and she says, well, Mr. Holden, I suppose you have a summation. Well, of course lawyers have a summation. They summarize what's happened and what the client wants, right? And I said, well, yes, Your Honor, I do. And she said, well, just give it to me if it's in writing. And I said, well, with respect, what has happened during the trial means I have to make some modification to it. She said, oh, fine, I understand that. Just give me just give it to me what you've got. Well, she's looking at her watch, and I realized what she was thinking was she's in the Sunshine Coast. If she leaves now, she'll catch the next ferry, and she'll be home in a decent time. If she doesn't get out of the court quickly enough, then she's going to miss that ferry, and she's going to be stuck on the coast for a while. And I said, and I have some cases as well. And she sort of rolls her eye, and she said, all right, well, give those to me too. And I said, well, I would like to explain how they're, how they apply. And she said, I'm sure I can figure that out. So she cuts this off, right? And then she gave a written decision, obviously because she wasn't going to come all the way up the Sunshine Coast to give a verbal one. She gives a written decision, and she had the facts all wrong. I mean, there were 7 or 8 places where she just completely got the facts wrong. And then she got the law wrong. In construction contracts, there's fixed price, there's cost plus, and there's another one, which I can't even remember because I had to actually go out and research it before I went to trial. And then she completely ignored my cases. She had to, because had she looked at the cases, my client would have won. But she ignores the cases, which is a error at law, and she got herself involved in the trial, which is an error at law, and she got the facts wrong, which are errors on the facts. And she finds in favor of the contractor. And my client was just, well, I was astounded. My client was just, she fell over backwards. She said, what, are you kidding? And she said, what can I do? And I said, well, you can appeal from small claims court to the BC Supreme Court. And she said, do it. I said, well, wait a sec. Your claim is for this amount of money, and by the time we pay the filing fee and you pay legal fees to a lawyer to go to the Supreme Court of BC, you're going to wind up paying way more than you'll get. And she said, I don't care. Do it. So we filed an appeal, and we get into the Supreme Court of BC. Now, he could have brought a lawyer with him, but he didn't, because he wanted small claims. It was so obvious that to him that he should just get more money because he obviously didn't bid the job correctly. And so he didn't bring a lawyer, and I went there. My client came with me, but she didn't have to because this is an appeal. We don't have witnesses again. And so I got up and I basically argued with the judge, pointing out all the errors at law and all the errors on the facts. And the Supreme Court judge is sitting there going, he couldn't believe it, right? So I'm most of the way through, and he says, Mr. Holden, he said, just tell me what you want. Okay. So at that point, I knew I'd won. Okay. So I said, well, I want this contract declared to be, or his actions declared to be a fundamental breach of the contract. I want the parties put back in the position they were in before the contract came into existence to the best of the court's ability. And he said, fine, Mr. Holden, you got it. And the contractor was, what? But I won before, and he was like, he just didn't know what had happened, which is a good reason why, if you're going to the Supreme Court of BC, even though they say you can do it yourself, talk to a lawyer beforehand. Anyway, so we won on appeal, which means my client basically gets the windows that are half finished, has to fix the windows in her house, but at least she got her money back. So anyway, that a long anecdote to explain why you get to choose your arbiter, and that's an advantage. She was a phenomenally good family law judge. Judge, sorry. But she probably hasn't done a commercial law suit since she got out of law school. She went through law school, went through articles, began practicing family law, practiced, got appointed as a judge, a family law judge. But just because you don't get actually appointed as a family law judge, you get appointed as a judge, and you do family law matters, except when they have a situation like this. 9 times out of 10, most judges probably could have done the commercial law thing as well as the family law thing. But obviously she just could not. So we got a bad decision. If we go to arbitration, we could, and it was a technical legal matter like that, there would be a retired judge on the list of arbiters, and we could choose that judge. But better still, we could choose a retired business person who had worked in the construction industry all his or her life and would actually know the difference between fixed price and cost plus. Okay. So you get to choose your adjudicator. If you've got an insurance matter, you get an adjudicator that has insurance experience, and so on and so on. Now, the next advantage is more flexible hours. And this sounds odd because I already said it's you get to a hearing faster. You do. You get to a hearing faster. The thing is about that, well, another anecdote. Here we go again. I had a Supreme Court trial, and I went down with my client to the Supreme Court House on Smythe Street. And we get down there at 9 o'clock, which you're required to do, and we go in and we go to the court docket listing on the wall, and we look for our courtroom. No judge has been assigned. Uh-oh. So then we go in and we go to the court registry, and they said, oh yes, the judge is sick, so you're going to have to go over to court scheduling and get a judge. We went over to court scheduling, and I mean, judges get sick or, whatever. And there were quite a number of lawyers there, and they're all arguing with the clerk about who should get the judge. Finally, the clerk said, stop, oh, quiet. He said, okay, who here has a serious matter? And I went, I do. And they all turned around and looked at me, and I said, yes, my case involves a woman who's going to be put into a home because she's incompetent, and the family's fighting over which home she goes into, and this is really quite critical. And so she said, okay, you have courtroom such and such, and the other lawyers are looking at me like knives in their eyes, like. But I'm there to serve my client as best I can, so I sort of jumped the queue. So then we go up to courtroom such and such, and we're sitting there and we're waiting, and it's 10 o'clock. Court starts 10 o'clock. 10:15, we're waiting. 10:20, we're waiting. 10:25, we're waiting. 10:30, 10:35, in comes the judge. Why is she so late? Well, she's so late because she was not planning on being a sitting judge that day. That day was her day off so that she could have fun, right? No, so she could sit in her chambers and draft the decisions on all the court cases that she's been hearing. But anyway, she gets assigned to us, so she had to read the file before she came in. So we don't start until 10:35. 12 o'clock, we break for lunch. It's a 2-hour lunch break so that she can go out and have martinis with her friend, right? No, so that she can go back to her chambers, make sense out of the notes that she's been taking that morning, and then work on her other judgments, and then come back at 2 o'clock. Anyway, she comes back at 2 o'clock, 4 o'clock, we adjourn. But we're not done. Doesn't matter, we adjourn. So we have to come back the next day, and I'm billing my client for this whole thing, right? Well, we had 3 hours and 25 minutes of court time in an 8-hour day. Okay? The best you can do is 4 hours in an 8-hour day. That's just the way the system is set up. So that's a problem. But if you go to arbitration, the arbitrator, and if they're good, and most of them I haven't heard any complaints, they'll arrange to meet you at 7:30 They don't have courthouses. You either go to their center, which I think is on Broadway, or if you're both in North Vancouver, the arbitrator will come over there. He'll book a room in a hotel. He'll say, see you there at 7:30. You come in, there's little pastries and coffee, and you get at it. Okay? At 10 to 12, your stomach goes off and you're hungry. And he says, I think we should get some lunch. And you go, yeah, okay. And you're just about to get up to go out to lunch. And he says, I'll have sandwiches and coffee sent in. Oh, okay. So then you work through your lunch hour. And then you work in the afternoon. It's about 5 o'clock. Well, court adjourns at 4. You're still there at 5. And he says, okay, it's getting a little late. Where are we? And I say, well, I've finished my submissions. And the other person says, I've got maybe 10, 20 more minutes. Okay, let's just continue going. And you'll go through and get it done quickly because they are much more flexible in their hours. The more they do, the more they get paid. A judge has a salary, if there's no court cases, which would never happen, but if there were no court cases, they'd still get paid. Okay, no, not so with an arbitrator. And then, of course, the other advantage you have with an arbitrator is they will view the scene. When I was articling, I got to follow lawyers around carrying their briefcases when they went to court, and I get to watch them and learn, right? And I went with one that was a motor vehicle accident. There was like 3 cars involved, and it was an intersection like this with another road coming in there, and there was a green Toyota and a red Yaris, and they were going this way and that way, and the lawyers started arguing about who was where and what happened, because there were 3 cars involved. And the judge is going, I don't understand. It was the green Toyota coming this way, and the Yaris, and the truck was, no, the truck was over here. And finally he said, I've heard enough. I'm adjourning this matter. See you tomorrow. He just stopped the trial. And they came back the next day and they had a big diagram, with the roads marked on it and the little cars that they could move. And it still got confusing. And it took a long time before the judge said, okay, I think I got it. In an arbitration, they'll look at the scene. I had Patrick Williams, who used to be the president of the BC International Commercial Arbitration Center, come out and be guest speakers. Unfortunately, we cannot get him in this term for obvious reasons, and besides, he's retired. So he was involved in one where there was a building and there was scaffolding, and somehow the scaffolding collapsed and caused an accident in the road. And the road was quite a ways away. And they're in the arbitration, and the arbitrator says, okay, I don't understand. The scaffolding collapsed here. How did it cause motor vehicle accidents out there? Like, it's not tall enough to... Both parties sort of look at each other and go, don't know. So he said, okay, let's go. And they go, jump in the car, they drive down. There's the building, there's the scaffolding, there's a really steep hill, there's the road. Arbitrator says, okay, I know what happened. Right? So they will go out and view the scene. Now, preserving ongoing relations, an incredibly important advantage in arbitration, and I am sorry, but I've got another anecdote which explains this, because if I just say that, it's really not very meaningful. If you sue someone and you win, and then you say, and by the way, I need more product from you next month, that's not going to happen. Okay? If you sue someone and they win, you're probably not going to order any more product from them. But even if you did because you sued them, they'll say no. Arbitration provides you an opportunity to preserve your ongoing working relationships while having the matter go to arbitration. First of all, just saying it's going to arbitration sounds less adversarial than see you in court. I had a corporate client. It owned 2 restaurants, and the owners of the corporation were a husband and wife. Pamela, the wife, ran the business. The husband, Chris, was the baker. And they were Italian restaurants, and they sold fresh baked Italian goods. They were so successful that other businesses, they started selling their fresh baked goods through retail outlets, specialty food stores, and other restaurants said, "Wow, we would like to sell your goods." And so Chris, the baker, worked out the how to freeze it so that it could be baked on other premises, fresh, freeze the dough, and then baked fresh on other premises. They had 2 bakeries in their, one in each of their restaurants, and they had to get a 3rd restaurant going 24/7. Basically, that's how well they were doing. Well, one day in one of their restaurants, a fellow walks in, he sits down, he orders a cup of coffee and some of the pastry, and he has a couple of bites of the pastry and some coffee, and then he orders another piece of pastry and has a bite of that and some coffee, and then he orders some other pastry, and the server came over and said, "Oh, gee, I'm sorry, sir, is everything okay?" And he said, "Oh, yeah, fine." He said, "But you're not eating it all." And he said, No, that's fine, and please bring me something else." And so she brings him something else, and by the time he did, the 5th one, the server's so worried, she goes and gets Pamela, and Pamela comes out and goes, "Oh, I'm sorry, sir, what's wrong?" And he says, "Oh, absolutely nothing's wrong." He said, "As a matter of fact, I would like to sell your freshly baked pastries in my restaurants." And Pamela says, "Oh, well, how many restaurants do you have?" And his answer was, "Only 22. Ching ching, she gets dollar signs in her eyes, right? And apparently he had restaurants in Washington State, Oregon, and Northern California. Sort of like those family restaurants, Sherry's and Denny's and places like that. Anyway, he says, have a supply agreement drafted by your lawyer, which means you pay for it, and then we'll review it, and I'll sign it, and then you can start selling me your baked your dough so I can bake them. And I got to do the agreement, which got me sort of goosebumps, because it's not only is it drafting a contract, but it's a complex one, and it's cross-border. Okay, so I was drafting this contract, and I went to meet with Pamela for one of the drafts. We're talking about the delivery and who's responsible for what and how it's done and when, how often, everything. Then we get down to the what we'll call boilerplate clauses, and we'll come back to that later on. Standard clauses that lawyers generally put in, and one of the ones that I always put in every one of my contracts and have for the last 10 years is an arbitration clause. Well, I put in arbitration, and it says this is any disputes with respect to the contract or the subject matter of the contract shall be referred to arbitration, and the arbitration shall take place in the BC International Commercial Arbitration in Vancouver. And Pamela said, "Oh, he'll never go for that." And I said, "Well, why not?" And she said, "Well, because he's American, and he's in Seattle." And I said, "Well, let's put it anyway, and if he says no, take that out, then we can say, well, we'll take that out if you leave this in, or use it as a bargaining ploy." So anyway, we leave it in, and we get it done, and we have a meeting with him. Either he is a lawyer, which is often the case, or he's done this so many times he knows what to do, because he's there without a lawyer. I'm there with Pamela, and we're going through the agreement, and we said, this clause, and he goes, "Yeah, sure." This clause, "Yeah, sure." This clause, "Yeah, sure." And I'm thinking, what have I missed here? Generally when you negotiate with an American on a business deal, afterwards you check to see if you still got your gold fillings, because they're great at it. Anyway, I thought, oh, okay, so good. And we get down to the arbitration clause, and I say, "Disputes with respect to this agreement or the subject matter thereof will be referred to arbitration in Vancouver." And he says, "Yeah, sure." And Pamela goes, "What? Really? You agree with that?" And I wanted to stomp on her foot and say, shh. But anyway, he looked right in her eye and he said, "Lady, have you ever gone to court in the United States? Believe me, you do not want to be there. I will happily drive 3 hours from Seattle to Vancouver to go to arbitration." Okay? She starts supplying him with dough. Everything is going swimmingly. I can't remember what it was, like 3 or 5 months later, one shipment is defective. But there was no one was sure whether it was defective from Vancouver to Seattle or from Seattle he distributes it to his 22 restaurants. He said it was defective when it arrived. She said, no, the problem happened when you distributed it. And they get in, yes, no, you, no, you, no, you, no, you. And Pamela's a bit of a hothead, and she said, okay, fine, we'll see you in court. And she slams down the phone. She calls me up, and I said, okay, well, we cannot see him in court for two reasons. Number one is we put in an arbitration clause, and number two, you don't want to go to court. And I said, why don't you call him up and say, look, got a little argumentative there, and I've taken the file and I've given it to my assistant, and perhaps you could do the same, and then we'll let them discuss the matter. Because in actual fact, it's either my insurance company that's going to pay for it, or your insurance company's going to pay for it, and we shouldn't waste our time on this. And he said, that's a good idea because I need more product from you next month. Sue him and see if he will say that. Okay, so you can preserve ongoing relations. Now, I've put in arbitration clause in my contracts for 10 years, and there's only been about two disputes, and they've both been resolved through mediation. So I'm probably shooting myself in the foot because I'm wasn't getting this much court work, but I have happier clients. Okay, so you can preserve ongoing relationships. The other one is advantage is the award is final and binding. It says that right in the Arbitration Act or the International Commercial Arbitration Act. Bingo, that's it. You have one shot. After that, you lose, you lose. You win, you win. Now you think, oh, I lost, but I should have won. Too bad. Okay, but at least it's over. You don't have to wait 3 years to get into the Supreme Court, lose, appeal, wait 2 years to get into appeal court. Because as I say, the defendant goes out of business and bingo, you've gone through all that and nothing happens. So the award's final and binding. At least you don't have the sword of Damocles dangling over your head. It's enforceable as a judgment. How can it be? He's not a judge or she's not a judge. They're just an arbitrator. Well, you get your arbitral award. You go down to the courthouse and you say, hi, here's my arbitral award. And they go, they stamp it, you pay some money, and bingo, it's turned into a judgment, which you can then start to use to enforce your judgment, which means try to collect your money. Okay? And then the other advantage is it's enforceable internationally, which is, and there's a bit of a funny story behind that too. In 1958, the United Nations had the League of Nations before it and the United Nations after World War II always worked towards making international relationships better. Okay, and commercial matters, they work to make commerce better. So you have the International Convention on the Carriage of Goods by Air, you got the International Convention on the Carriage of Goods by Sea, you've got the International Convention on the International Sale of Goods, all sorts of conventions, right? Well, in 1958, the United Nations passed a convention which would allow a BC judgment to be enforceable in Mexico or in France or in the United States or in Colombia or Australia, and vice versa, so that it would facilitate business. Disputes could be settled, claims could be paid. Most countries signed the convention, but the convention does not become law just because the country signs it. They have to do what they call enabling legislation. So the U.S., Mexican, Canadian agreement on trade, which was renegotiated by Trump, and just because he renegotiated it doesn't mean it was law. It took Congress a long time to actually get around to sign it. And Mexico signed it, and I believe we signed it. I'm not sure. So you have to have this enabling legislation. Well, after the Convention on the International Enforcement of Judgments was passed by the United Nations, all these countries said, whoa, wait a sec, we're giving up jurisdiction. It means courts in other countries can affect Canada and vice versa. And so only about 5 countries in the world actually passed enabling legislation to make this applicable. Okay, and they're not the the barn burner countries as far as commerce goes. The United States didn't do it. England didn't do it. Canada didn't do it. I don't even think China was involved then. All the European countries didn't do it, with the exception of a couple. So it was defunct. It was of no force and effect. But at the same time, in 1958, they passed a convention for the international enforcement of arbitral awards. All the countries signed the convention, and then they all acted, most of them anyway, enacted enabling legislation. Okay, and so it becomes the law of the land. Why would they do that? Well, hardly anybody was doing any arbitrations back in 1958. So it wasn't considered to be of any real significance. Now, however, that allows a arbitral award from British Columbia to be changed into a judgment, taken down to Jalisco, Mexico, and you can enforce it without going through another trial. If I took a judgment of a court in BC down to Jalisco, Mexico, they would say, oh, well, you got common law, we got civil law, you better have another hearing here. And it could be doubly costly and twice the delays in order to get your judgment registered. A judgment from BC was taken down to Missouri, and I knew about this one. And the judge down there, when they tried to register, the judge down there said, first of all, he was confused. He thought British Columbia, was in South America, and then he said, "No foreign judge is going to tell me what I can do in my state, in his state." And he refused to allow it to be registered down there, which means we would have had to appeal to the Court of Appeal in that state. And it was just getting too costly for the client, who said, okay, just forget the thing. But an arbitral award can be registered down there, no problem. Okay, so those are the advantages. The disadvantages: no body of precedent. Well, if arbitrations are confidential, there's no way that arbitration can ever be used as precedent in a subsequent arbitration. So that is a disadvantage, but it's insignificant, because when we had the Arbitration Act, or the International Commercial Arbitration Act, passed, people did not stop going to court. There are still thousands and thousands of court cases taking place. Those court case decisions can be precedent. So the fact that a few arbitrations aren't being precedent is not a significant disadvantage. Limitation on equitable relief. There are equitable remedies besides the common law remedies of damages and injunction. Quick example: specific performance. I want to buy a piece of property. The law has a rule that no pieces of property are identical. So if I wanted to buy that property, and you said sure, and then I gave you the deposit, and you give the money back and say, no, I don't want to go through with it, you're breaking your contract. So the judge says, well, take the damages and buy another piece of property. Well, the other piece of property isn't identical. You don't want another piece of property. You want that lot. So courts have the inherent jurisdiction, besides the legal jurisdiction of damages and injunction, to say specific performance. You signed a contract, you agreed to it, you have to now specifically perform it by giving that person the property. Okay, that works for land. Other things like, well, let's say I wanted to buy the Mona Lisa. I wish I had the money to buy the Mona Lisa. Anyway, I want to buy the Mona Lisa, and he refuses to sell it. Well, damages is not an adequate award, okay? And he gives me a bit of damages and says, buy a different painting. No, I want this Mona Lisa. There's only one of them. So I would argue specific performance. He must perform the contract and give me the Mona Lisa. Well, the courts can do that. Arbitrators can't. Right in the Arbitration Act, it says they are not judges, ergo they do not have the inherent jurisdiction to give equitable relief. That would be a really big disadvantage if that section ended there. But it doesn't. It goes on to say, cannot grant equitable relief unless the Arbitration Clause specifically provides for it. So that cannot be a disadvantage. Unless, of course, you don't get a lawyer to draft your arbitration clause. Okay. So if you just went onto the arbitration website, they have sample clauses. You pick one, you use it. You're not going to get the equitable remedies. Okay. So you are at a disadvantage. But if you go to a lawyer, like if you came to me, for example, I have a standard arbitration clause which includes that the arbiter can grant equitable rewards. So again, it's not a real disadvantage. Okay, no day in court. This is on the list. I think it's a bit of a joke. But I had a Supreme Court judge, a Court of Appeal judge come out and talk to my class years ago. And he specifically talked about the court process and then had questions about arbitration. And he said, one of the disadvantages of arbitration over going to court is that the people involved do not feel as though they had their day in court. And I almost laughed. And then I realized he was being serious. And of course, he has to be serious. He's a judge. So he has to feel like people feel satisfied if they go through the court system. I don't think I have ever seen or would ever see somebody get sued and lose and say, "Gosh, golly, gee, I lost, but I feel so good that I had my day in court." Or a plaintiff that sues somebody because they owe them money, they don't get their money, and they say, "Darn it, I didn't get my money, but, well, I didn't get my day. I had my day in court, so I guess everything's okay." So I put it on there because, after all, he is a Court of Appeal judge, and I am just a professor at the university. But I don't think it's a serious disadvantage. Limited right of appeal, as I mentioned, it's final and binding. There is a section in the Arbitration Act, in the International Commercial Arbitration Act, that says awards may be appealed, but only in very restricted circumstances. So if I was an arbiter and I said, yes, there was a binding, valid contract between the people, but I'm just not going to enforce it, well, that would be a palpable error at law, okay? And you could appeal to the courts. But if there is a binding contract and I interpret it to mean something different than the parties, you don't get to appeal that, okay? Because that's my award based on how I read the contract, not a error at law, okay? So you can appeal, but it's very, very restrictive. All right. Now the fifth disadvantage is that it's unethical or illegal. There could be unethical or illegal uses of it. And that came up in the Heller versus Uber case. Heller was a Uber driver in Ontario, and Uber, of course, is a company out of Maryland, United States, and Heller signed a contract, and it was a take it or leave it contract. You don't get to negotiate with them. So he signed it, and then Uber dismissed him as a driver, and he went to the Employment Standards Branch in Ontario and filed a claim. And Uber Technologies said, no, you cannot do that. You signed a contract that says this matter is supposed to go to arbitration. And usually that would be the end of it, okay? Because if you have a contract that says it goes to arbitration, the courts have no jurisdiction to hear it. The problem in this case was Uber said, you have to take this matter to arbitration. And oh, by the way, the arbitration takes place in the Netherlands, in Europe. And the judge went, what has a U.S. company that's dealing with a Canadian driver, what's the connection with the arbitration center in Amsterdam? And the only connection was Uber realized there's no way that Heller could afford to fly to the Netherlands and go through an arbitration there. So he would lose his rights. And the judge said that clause is unconscionable and is therefore void. which meant that his claim at the Employment Standards Branch could go ahead. All right? Because the judge said there's always a potential that I'm big and I say to you, this is going to go to arbitration in New York, and you're a Canadian business, and you have no real a way of negotiating out of that, so you accept it, right? And that's a bit unethical. The more ethical approach would be to say, if we go after you, it's in New York. If you go after us, it's in Ontario. Okay, that would be ethical, right? So it could be unethical, and that is a problem, because the courts deal with illegal matters. But in this particular case, the court said it is illegal to do that. And so that's unconscionable, and it was struck down. So there can be unethical and illegal uses of arbitration clauses. All right, that's a serious problem. So far as in the world that I know of, we are the only jurisdiction, meaning Canada, that has taken that approach against an unethical and one-sided arbitration clause. Because that's an Ontario decision, of course, of the Ontario Court of Appeal, I believe, then it would be equally applicable in British Columbia, because if a situation came up in BC, BC could follow that law. To conclude, we have three statutes. We have the Arbitration Act. So a BC business going after a BC business can go to arbitration in BC under the Arbitration Act. If it's a BC business and a business in any other country, you can go under the International Commercial Arbitration Act. If it's one of the USMCA countries instead of the North American Free Trade parties, then you can go to the Commercial Arbitration and Mediation Center of the Americas, or CAMCA, according to Article 2022 of the agreement. And under that, when the negotiators put that in, they didn't do that in the last sort of go around. This was a previous amendment to the North American Free Trade Act. They decided that the disputes under the North American Free Trade Act were solving public law matters. Nothing for private law, though. So if I was selling someone in Mexico milk and they didn't pay, I could not go after that company under NAFTA, because there was no public law aspect to that. It's just a private contract. So to make NAFTA even better, the negotiators put in this Article 2022, which would give the BC business an avenue to go to arbitration instead of trying to sue a company in Mexico. Okay? The BC International Commercial Arbitration Center in Vancouver is the center for Canada. There's one in New York for the United States, and there's one in Mexico City for Mexico, and there's one in Quebec City for Quebec. How did this all happen? Well, obviously Mexico City, because that's the capital of the U.S., New York, because New York had years and years and years an arbitration center. In Canada, you would think it was either Ottawa as the capital or Toronto as one of the key commercial centers, but no, they chose Vancouver because Vancouver had the BC International Commercial Arbitration Center that had been operating for years. Okay, so there's an advantage. When I talked to Patrick Williams, there has never been a Vancouver arbitration under CAMCA. So it's there, but it hasn't been used. Okay, that's good, because there is the Convention on the Recognition and Enforcement of International Foreign Arbitral Awards, which means that the awards have international application. Right at the bottom of slide 34, it says risk management practice. What this means is how do you reduce the risk in an international contract? And one of the ways is to put in an arbitration clause. If you do not put an arbitration clause in that contract, you will not get to arbitration. So let's say you and I have a contract. We do not have a clause in there. And I say, okay, I'm going to sue you. Oh, wait, no. Let's agree to go to arbitration because it's faster and that's an advantage to me, and it's less expensive and that's an advantage to me. What are you going to say? You're going to say, no, see you in court, buddy, because then I have to go down, meet with my lawyer, write out a $35,000 retainer to them so that they'll fight the court case. That's probably to start. It's going to be way more than that if it's an international contract. Well, so you'll never agree at the point of the dispute. But if we put that clause in the contract and I say, okay, we're going to arbitration, you go, no, I want to go to court. Too bad, buddy. We've got an arbitration clause and you've agreed and it's going to arbitration. Okay, so you should put an arbitration clause in there and you should make sure your lawyer drafts it. A lot of self-help stuff out there. And when you go to the BC International Commercial Arbitration site, it actually has some draft arbitration clauses. So you take one of those and you use it. What do I have to hire a lawyer for? Like, why hire a lawyer and have them charge me, $250 or, $400 to put in a clause? Well, would you remember to put in the equitable relief clause? And then the other thing is, when I draft my arbitration awards, I suddenly realized that arbitrations are less costly than court, but still very expensive. So if the matter is worth less than $35,000, I put in a clause that says the parties can decide whether they go to small claims court, and if they decide, then that's it. Or if they decide they want to go to arbitration, they go to arbitration. So if the matter was $25,000, I wouldn't go to arbitration. What I would do is I would say, okay, I'm going to go to small claims court because the limit of small claims court is $35,000. My claim's $25,000, so I qualify to go there. I can handle the dispute myself, and I do not have to hire a lawyer. Small claims court is set up so you can do it yourself. Okay, but if it's an $80,000 matter, hey, you cannot go to small claims court. You do not want to go to the Supreme Court of BC. That's when the arbitration clause kicks in. So risk management practice, put in an arbitration clause and make sure that it's drafted by your lawyer. All right, so that finishes the Canadian legal system, and the next topic will be the U.S. Legal system, and we'll start a new video for that one. So that's all for today. Thank you very much.